like over the last decade, I would say constitutional scholars who take original meaning very seriously have begun to kind of fill out a theory that you might call fiduciary constitutionalism. The idea of fiduciary constitutionalism is that the Constitution, by design, was meant to be some kind of private law fiduciary instrument in which officers serving under the Constitution were going to be thought to have some form of fiduciary obligations. The scholars like Gary Lawson and Guy Seidman, who just won $50,000 care of Randy Barnett for their new book. We'd like some of that money too. But power of attorney, the great power of attorney, they argue together that that there are intimations that by design the Constitution was meant to be a sort of power of attorney, and the people who serve under it are limited in the way agents were in 1787. Rob Natelson, who had written articles really for 10 years, making similar arguments about the necessary and proper clause, suggesting that indeed officers who serve under the Constitution are limited by fiduciary obligations. But what this kind of family of theories and scholarship has in common is that it really takes as a point of departure that the private law of fiduciary obligation was extant at the time of the framing, and that in a sense what the framers were doing was picking off the rack a kind of form of legal relationship that already existed. And what we set ourselves the task of trying to do was trying to evaluate that broad set of scholarship and try to evaluate whether there were intimations that we could find in the Constitution that validated this theory. And we thought to look in the presidential oath and the take care clause, which both use the language of faithfulness, very common or evocative of fidelity that we imagine at the core of the private law of fiduciary obligation. But the story we found, I think, tells a pretty radically different story from the ones that have been proffered over the last 10 years.
Yeah, and I think what we really ended up finding is that there's, certainly fiduciary law in the private sense, has roots that go back, hundreds of years before the American founding. But seemingly, to us at least, even deeper and more coherent was what we, among ourselves, kind of came to be to call a law of offices. I think we generally say a law of public offices, but also we saw it in a lot of private offices as well. And the sort of core of the paper is tracing this law of offices and how the language of faithful execution, particularly when it was instantiated as an oath of office, came to have some meanings that look a lot like, we argue, modern fiduciary law, but do not have their origin there. And as you see, the paper starts in the 1200s in English legal history and kind of marches forward. We don't pinpoint exactly when we think the faithful execution language absolutely came to have the meanings that we claim for them by the time of the founding. We think it was a long process of development. But we trace really an enormous number of oaths. Interestingly, I think for middle and lower level officials, both in England and then in colonial America, and then post-independence in the United States, that imposed faithful execution duties that were concerned with officers who held these posts, not taking private and illegal profits from the office, that were concerned with officers not acting in an ultra-virus way, wanted them to abide by the law that set up and governed their offices and empowered them, and that imposed duties to act diligently, impartially, duly, et cetera, et cetera. There's a whole series of adjectives that we found associated with faithfulness over the years. And we think this was kind of a gradually developing law of offices that got content and coherence from a bunch of different places, in part from a developing criminal law. The idea of a misdemeanor, at least in part, meant failure to demean oneself appropriately in office. And so there was a criminal law that could, either at the instance of the Crown or at a private prosecutor, could seek to remove people from their offices for a series of failings, including taking illegal profits, exceeding the duties of their office, acting negligently, betraying the public trust in some way, say taking a bribe. We also found a developing meaning for this law of offices in impeachments. We've started, actually, it's a little late now since the paper's already been accepted for publication, but we've been actually starting to find some civil cases where removals or replacements of officers were effectuated for unfaithfulness in office, seemingly for the same set of reasons that we've identified. And what we end up arguing is that, again, sort of tabling the question, because I don't know that it's knowable of precisely when these meanings were really coherent. We argue that certainly by the latter part of the 18th century, when an oath of faithful execution for the presidency was imposed, we think it would have been quite well understood what a sort of package of duties or a set of restrictions on that office, came along with that. And as I previously said, we think it's quite significant that the presidency was given this oath and this duty to faithfully execute the law that was really most closely associated with mid and lower level officers. There was a pretty obvious available form of an oath for, if we want a kind of imperial chief magistrate, and that would have been something looking a lot like the coronation oath for the British king, and that was not chosen. Something very, very different was. So Ethan, I think we'll just talk for a couple minutes about several other things, but I didn't want to neglect to say thanks to Mike and Mike for having us here. We really look forward to your comments, and certainly are interested to hear from those of you who are kind of truer originalists than we are about what you think about our methodology and whether you think we've presented the case in a way that is compelling.
Andrew is embarrassing me because I was supposed to start with a thank you, but I just went right into it. I just want to say maybe two final things by way of concluding our presentation. One is that to the extent that we think our historical findings make important interventions into constitutional debates today, I think we feel relatively confident that to the extent that the Take Care Clause and the presidential oath are utilized by presidents, scholars, and others to empower the president to support some kind of imperial theory of the presidency, to underwrite unilateral executive action. I think what we have to say to that is that it looks like, as a matter of original meaning, both the Take Care Clause and the presidential oath were intended to be language of discretion limitation. And that seems to be a really important conclusion that for many people is obvious, but I think that our historical record firmly supports that. The other dimensions that intervene into contemporary constitutional law debates are really about issues surrounding self-dealing, which seem like prominent in discussions today. And I think to the extent that our historical findings make some intervention there, what we found over and over again was that oaths and take care clauses often came together. They often came with bonds or sureties to make sure that officers did not take undue profits from their offices. And so no self-dealing limitation seemed to be baked into this method of discretion constraint. The last thing I want to say, though, by way of caution, and I'll conclude there, is that very little that we have to say is about enforcement mechanisms that were baked into the Constitution for what to do when somebody is in default of their substantive obligations. And I don't think this paper is taking a position on that. We try to say that many different times. But it remains the case that many of you will still ask us what is the right method of redress when there is a president who has violated the oath or violated the take care clause. And there's nothing in this paper that answers that question.
Except impeachment.
Yeah, we know that there are, but we have a gamut, right? As you said a minute ago, we also have civil cases where you have different kind of removal. And so I just, I think like we have to do more work to figure that one out. And thank you so much for taking the time to read a long and hard paper.